daily fantasy sports has emerged as a new frontier and is certainly growing in its popularity. Major League Baseball, the NBA, the NHL, and the NFL have all partnered with daily fantasy sports in some fashion or another. Television coverage of the NFL now includes entire programs devoted entirely to fantasy football. In terms of market size, the daily fantasy sports industry is still relatively small. However, its growth has been astonishing, with estimates suggesting that player entry fees will soon exceed the total amount wagered annually on all sports in Nevada. Those estimates predict daily fantasy operators will take in $17 billion in entry fees each year by 2020. This growth and the attention that has come with it has sparked confusion around the vague patchwork of federal and state laws governing these websites. Lawmakers in Indiana, Massachusetts, Pennsylvania have already introduced legislation, while New York currently has 4 bills pending. And as fantasy sports continues to grow in popularity, more states are likely to weigh in. In California, we have the opportunity to lead the way and set the tone for how to balance consumer protections with consumer demand. Recent events reported by the New York Times have highlighted the need for action in this area to plug the gaps that currently exist in our laws. When the federal government passed the Unlawful Internet Gambling Enforcement Act of 2006, they assigned jurisdiction over daily fantasy sports to the states. As the legislature, we are not here today to decide the legality of daily fantasy sports in California. That is a question that lies with the courts and our Attorney General. We are here to consider how and what safeguards can be put in place to ensure games are fair, to prohibit underage usage, to prevent compulsive play, to guard against identity theft, and to ensure consumers are competing on a level playing field. It is with these goals in mind that we convene this hearing.